The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Thank you, Rachel. Good morning, everybody. Welcome to the Fourth Circuit. We're ready to hear argument on our first case, United States v. Williams. Mr. Compton, we'll be glad to hear from you.
Thank you, Your Honor, and may it please the Court. My name is Nicholas Compton, and I represent the appellant in this case, Alan Williams. Mr. Williams is appealing the 327-month sentence of incarceration and the lifetime sentence of supervision imposed on him by the district court. Mr. Williams contends that the district court failed to make an individualized assessment of him when imposing both the sentence of incarceration and the sentence of supervision. He further contends that the district court relied on information that was not provided to him prior to sentencing. And lastly, he contends that the district court failed to give proper notice that it intended to depart above the high end of the guideline range prior to sentencing. With regard to the first ground, Your Honor, in imposing sentence, the district court is required for both an incarceration sentence and a supervision sentence to make an individualized assessment of the defendant. The district court made no such individualized assessment in this case. With regard to the sentence of incarceration, the district court's explanation as to why it was imposing the 327-month sentence above the high end of the guideline range is totally based on the nature and circumstances of the offense, to the exclusion of the other 3553A factors. Even though those factors were raised in mitigation by Mr. Williams, both in a sentencing memorandum filed prior to the sentencing and at the sentencing hearing itself.
So did you make that specific counsel, did you make that specific argument in your brief?
About the individualized assessment, Your Honor?
Well, I know in general terms you say individualized assessment, but your argument that the court didn't consider specific parts of 3553, is that argument made in your brief?
I thought I did, Your Honor. Perhaps it didn't come across in the filings that I did. In my intention in the filings was to argue that the court did not consider all of those 3553A factors when both sentencing, incarceration, and supervision.
Well, when I read through in the appendix from pages 147 to 150, that seems to be a fairly intensive and specific finding as to the reasons for the sentence. What in particular do you say that the court did wrong here?
Well, Your Honor, we raised in the sentencing memo and its sentencing factors, including Mr. Himmelwright's lack of criminal history, his age. We raised certain matters with regard to his childhood. We provided 2 letters of character letters. We talked about his decades of employment as a firefighter and an EMT, and we provided over 60 pages worth of certificates, thank you letters, commendations. We talked about his mental health, which is...
Right. I mean, do you make any of those arguments in your brief?
I don't think we specifically referred to those, Your Honor. I think I generally referred to the court's failure to make an individualized assessment on both the sentence of incarceration and the supervision sentence. I don't believe I specifically referenced those specific matters in the brief.
Well, the law requires in every case of sentencing that the district court judge make an individualized assessment and go through the 3553A factors in some form, but if there's error, it's incumbent upon the defendant to tell us what exactly the error was. So that's the reason for my questions.
Yes, Your Honor, and I certainly understand that, and I can see where the court, just looking at the brief, I can see where the court did not get that. I probably should have been more direct in what I was referring to, as opposed to the generalized, individualized assessment. I think the court neglected, the district court neglected to review, to discuss those specific 3553A factors on the sentencing. I think likewise on the lifetime of supervision, the district court failed to make, again, an individualized assessment, providing on page 150 of the joint appendix a one-sentence justification for the lifetime of supervision, which says lifetime of supervision will also allow the probation office to monitor the defendant's conduct in the community and to ensure his compliance with the sex offender registration requirements and protect the community.
Counsel?
Judge Harris has a question.
Yeah.
Yes,
So I know that before the district court you did ask for 5 years, but were there any arguments at sentencing actually being made about the length of the sentence of supervised release? It didn't seem to me, and I'm not casting any fault on anyone, but it just didn't seem as though that was the focus of either the defendant's arguments or the government's arguments at sentencing. And given that there was no specific argument about why the term of supervised release should be 5 years, I guess I'm wondering what else the district court was obliged to say about it.
I think our overall argument, I agree with Your Honor. I don't think that there was a specific discussion about the full length and breadth of a sentence of supervision, but we did specifically ask for the 5-year mandatory minimum, and I think that our arguments that we presented in the sentencing memo at sentencing were in regard to both the sentence of incarceration and the sentence of supervision. We were asking for the mandatory minimums on both, and so I think
I thought part of your argument at sentencing went to you wanted a lower sentence of imprisonment and implied that a longer term of supervised release would be the appropriate way to keep an eye on the defendant. I mean, is that a fair statement of the argument that was made?
I think that probably is fair, Your Honor, and I've made that argument in the past, but I think that doesn't relieve the court of having to explain why it chose the sentence that it did, and particularly in this case a lifetime sentence of supervision. My suggestion to the court that perhaps a longer sentence of supervision in exchange for a period of a lesser period of incarceration, I don't think under the law allows the court to simply do what it did in this case, which is what it does or had been doing in all of its cases, including the Himmelreich case, which was also before this court, where it simply imposes supervision in these sex offense cases, divides the special conditions into 3 groups, and then recites the 3553A factors as the justification without specifically applying them to the defendant. Here, even if I had suggested that perhaps a longer sentence might be more appropriate, the court provides no justification as to why, for example, a 10-year sentence of supervision or a 40-year sentence of supervision is more
Mr.
appropriate
Compton?
for this defendant.
Mr. Compton?
Judge Rushing has a question.
Yes,
Thank
Your
you.
Honor.
You, on this line, you mentioned that your arguments for a shorter prison sentence and a shorter supervised release term, that they were overlapping. You were making the same arguments about both, why they would apply to both. So my question is, in reading what the explanation the district court gave, it seems that that was the way the district court also approached it. The sentence is announced, both the incarceration and the supervised release. And given that the reasons for both were the same in the argument, why shouldn't I read the court's reasoning to apply to the entire sentence, including the supervised release?
Certainly the court can read it that way. I think if it chooses, I think the district court, I may have presented the argument as combined, but I don't think the district court in its ruling meant for that explanation to apply to both. It provided separate, specific explanations in my.
Well, what the court said was the reasons for the sentence, and the sentence includes both the period of incarceration and supervised release, imposed here are as follows. And so we had following Judge Rushing's question, we had a case last year called Arbaugh that did exactly. Recognized exactly the same situation where the district court pronounces the combined sentence and goes through all of the rationales for it that apply to both. But unlike in Arbaugh, there is a specific explanation at the end of the district court's discussion that applies to the lifetime supervision. So my question is, why is this case any different from Arbaugh?
Well, Your Honor, I think that the district court has provided a separate explanation. I appreciate that it says it refers to just the sentence, but the district court makes a point of providing separate explanation when imposing the special conditions of supervised release. It doesn't announce the standard conditions and then the special conditions and then give its reason. It announces the standard conditions and the special conditions, and then after each, like 3 or 4 special conditions, my time has expired, Your Honor. May I continue?
You can go ahead and finish up your thought.
The court, after 3 or 4 special conditions, it stops and gives a reason why those conditions are being imposed on this defendant, except there's no individualized assessment on that. It's just
Counsel, I'm sorry, I know you're over time, but are you suggesting, is it possible that we're in your view, had the district court not said anything about supervised release, not put in that sentence at the very end saying that here's my sentence, here's my explanation, and then at the end, one sentence about the length of the supervised release term, if that sentence were out and the sentences, the kind of boilerplate language about the particular conditions were out, then that would be fine. That would be Arbaugh. But because the district court added something specific as to supervised release, now it's not okay?
I think in that instance, what the court has done here is by adding that language has separated its sentence, its explanations out. It has provided, in my view, an explanation for the sentence of incarceration, which is the long discussion that the court has when it imposes a sentence. and then has, yes, Your Honor, provided these three separate explanations, as opposed to, I think what perhaps Judge Agee was suggesting was that when the court said the reasons for the sentence imposed are as follows, I think that refers to this sentence of incarceration when looked in the context of the fact that the court has given separate explanations for the sentence of supervision.
All right. Thank you, Mr. Compton. You've got some time in rebuttal. Ms. Crockett, we'll hear from you.
May it please the court, Kim Crockett appearing on behalf of the appellees. Respectfully, Your Honors, the appellees disagree with the appellant's arguments in this case. And I'll begin, as Mr. Compton did, with the first argument. And that's that the district court imposed a variant sentence in this case. As this court is well aware, district courts can consider multiple bases in its decision to vary, and that those decisions or considerations can overlap with similar grounds for departure. But in this case, the court did not place more reliance on the departure grounds set forth in the PSR, but in justifying its sentence, relied on many, many factors to warrant a variant sentence above the guideline range. And I'll draw your attention to the fact that the district court, in its explanation for its sentence, never even used the words extreme psychological harm in reaching its determination. While we do believe the court did consider harm done to the minor in this case, it was an extreme psychological harm that was set forth in one of the bases for departure. But even assuming you believe a departure was imposed in this case, the appellant had notice. There were sections in the PSR that alerted appellant to those grounds. He filed a sentencing memorandum thoroughly arguing against it. And appellant began his arguments on behalf of his client with discussion of those departure grounds. So he was on notice. There's no indication that additional notice would have affected the presentation of his evidence or the ruling of the court. And unlike the court in Spring, there were only 2 grounds of departure that were noticed in the PSR. Appellant also had all of the same information that was available to the government in probation. And I wanted to spend a second talking about what I believe was the red herring in this appeal, which was the appellant's misleading arguments to the court that information was withheld from the defendant that was then used to depart upward. Which, if true, would be concerning. But in this case, neither the United States nor probation withheld anything from the appellant. The United States received an update from the victim's family, from the father, after the plea was reached, but before we went to sentencing. And that information was provided to the probation office and incorporated within the PSR. And the appellant had it for 2 months before sentencing. Paragraph 142 in the PSR in the joint appendix, page 194, is the sum and substance of that information that was considered. So the United States takes issue with the claim that the above guideline sentence was predominantly based on extreme psychological harm of the victim, and that evidence of that condition was withheld from the appellant. And I know there was some significant amount of time in the briefs that discussed that issue. At sentencing, the United States advised the court that during our plea negotiations, the defendant never requested records to support our claim for the restitution. And the government never had the victim's records in its possession. So the government merely requested $20,000 in restitution, which was accepted. And it was a bargain for agreement, quite frankly, Your Honors. And the defendant received the benefit of it because at the time we'd gone into our plea negotiations and he had signed the plea and had a change of plea hearing, the victim in this case had not been hospitalized, had not been placed in foster care. So had we not reached an agreement as to restitution, we would have had a hearing and likely the restitution figures would have been much higher. And then we probably would have had records that were in our possession that we would have shared. Defendant's trying to now in this brief tie the United States comments about what it had in its possession during our plea negotiations to later lay the foundation of the justification for probation putting extreme psychological harm as a possible departure ground in the PSR. There were no records supporting probation's assessment that were in the possession of the government or that were shared with probation. So there was no surprise and there was no prejudice to the appellant in this case. And I'd note the government never requested a departure on any grounds. The government never argued for a departure. In fact, we asked for a high-end guideline sentence consistent with the plea agreement. And the district court, we believe, never imposed a departure sentence.
Ms. Judge, can I ask you to speak to the question of these conditions on supervised release and whether they were adequately explained and tailored to this defendant?
It would be my pleasure, Your Honor. The United States does believe that the district court's approach to sentencing is consistent with our law. A lifetime term of supervised release, it was within the guideline range in this case, and it was the statutory maximum. And as you are well aware, special conditions must also be consistent with the pertinent policy statements that are in the Sentencing Commission, included within the Sentencing Commissions. And one of those policy statements includes the provision that a statutory maximum term of supervised release is recommended for those convicted of sexual offenses. And the appellant is a convicted sexual offender who committed hands-on sexual abuse in this case. So unsurprisingly, the court did just that. It imposed a lifetime term of supervised release.
And what about the conditions?
I'm sorry.
The specific conditions, I guess that's my biggest concern about the case, is whether each condition was explained sort of in terms that go to this defendant particularly.
Yeah, I believe appellant is trying to draw out one sentence within the court's overarching justification for its sentence. The court spent more than one sentence. It spent roughly 4 or 5 pages, laying a foundation for why it was imposing a sentence in this case.
I think maybe if I ask you just a very specific question. So one of the conditions, for instance, is that the defendant can never possess alcohol for the rest of his life. And I can't see anything in the record. If I were to judge whether or not that was reasonably related to the 3553A factors or more restrictive than necessary, I don't really know what I would look to. There doesn't seem to be anything in the record suggesting that there was an alcohol problem, that defendant abused alcohol or was, frequently drunk, or that there was any connection between alcohol and the offenses. So how would I find, if I were to review that, how would I know why the district court imposed it?
And Your Honor, the district court did not, in its justification for its sentence, draw out any particular fact as it related to Mr. Williams and the use of alcohol. And I cannot recall off the top of my head whether or not there was anything in his personal history that was noted in the PSR. But I do think when you're looking at the court's sentencing, you can't just look at one section of the sentencing. You have to look at the court's entire sentencing hearing as a whole. And when looking at that as a whole, I think what the court was trying to draw attention to were the concern about the personal factors that this appellant had.
Well, counsel, let me drill down on Judge Harris's question. When the court announces the special conditions, which I think start on page 141 of the appendix and goes through maybe 145, it announces various conditions, and then it interjects the reasons for those conditions. So, for instance, on page 142, it says you must not use or possess alcohol, and then it goes on with various other restrictions on the defendant that are special conditions. And then toward the bottom of JA 144, it then says, well, here are the reasons for my conditions. It assists probation in reducing the risk of recidivism, providing for the protection of the community, and reducing the risk of harm to third persons. So I think the question is, when the court interjects those rationales for the conditions that it's just announced, is that sufficient?
I don't believe that's the intent of the district court in this case. While the court does include those rationales after it imposes those conditions, I think that the court also justifies its sentence when it says, in reaching my decision as to the proper sentence, I did consider all those factors set forth in 35.
Right, but I think other than the term of incarceration and the term of supervised release, the conditions of supervised release are a different category. And so the district court provided explanations that were generally about the same for all these different conditions of special release. And I think the question for our court is that sufficient? And
I think even
and
read
if
alone,
so, why
I
is
think
it sufficient?
I think even read alone that this explanation is sufficient. It does offer probation a chance in assisting him in reducing recidivism. It does provide protection to the community.
But why is that true if he doesn't? Why is that true? That doesn't seem self-evident to me if he doesn't have an alcohol problem.
Well, and Your Honor, I wish I could recall what was in the PSR about alcohol, if anything.
He describes himself as a social drinker, and there's nothing else in there to suggest that that's not true.
Okay, and I appreciate the court's recollection on that. But I do think that even read singularly, this is sufficient to warrant the additional restriction. As it relates to the term of the supervised release, again, unsurprisingly, I think the court imposed that term for a lifetime based on the factors that it reviewed on the record. In this case, the appellant transported a minor that was entrusted to his care across state lines, had sexual intercourse with her, recorded it, photographed her nude using pinhole cameras, and distributed images worldwide. The victim or even uncharged conduct. I think the most compelling thing to our district court was the fact that the appellant was in a position of trust and garnered additional trust. He was a firefighter who met this family through a Make-A-Wish program. He was a school bus driver, and he was the roommate to the chief of police. And the court spent a lot of time talking about that trust, that violated trust, in reaching its determination. So as part of its individualized assessment of the defendant, the court considered him a menace to society, especially to the most vulnerable in society, like the victim in this case. In reaching its sentence, the district court took note of both the individualized characteristics of the defendant and particular offense conduct. In this case, spending, as I mentioned previously, multiple pages of the sentencing transcript devoted to justifying its sentence. And I believe that it needs to be read in whole, not pulling out one sentence at a time. And while you consider the extent of the deviation, in making that determination of whether it was appropriate, you must give due deference to the district court's decision that the 3553A factors on a whole justify the extent of the variance that was imposed in this case. We believe the district court properly calculated the guideline range, considered all of those 3553A factors, completed an individualized assessment of the defendant and the facts, and considered the arguments presented, and then imposed a sentence of 327 months imprisonment, which it characterized as a variant sentence, not a departure. The district court also stated all of its reasons with specificity in accordance with section 3553C. And the explanation for the sentence was sufficient to allow this court to have meaningful review and to promote the perception of fair sentencing. And we do not believe that the district court committed error in imposing a variant sentence of 327 months or a lifetime term of supervised release. And we'd ask the court to affirm the judgment.
So let me ask you, in the PSR, which the district court adopted and I assume then was provided to the defendant well ahead of the hearing, at page 188 of the appendix, page 18 of the 188. Condition 108 is you must not use or possess alcohol, and then there's a specific justification for that. It will assist the probation officer in reducing the risk of recidivism, etc. So is that specific justification for that item, which is then adopted by the district court and provided to the defendant, is that sufficient to explain the condition of supervised release?
I believe that it is, Your Honor. When looking at the recommended term of special condition from probation, probation is providing its justification for why it thinks that term is necessary. And the court, when it adopted the PSR, included that in its ruling or in the justification for its sentence. That was part of the court's findings.
But counsel, I thought, haven't we held that it's not enough that a condition of probation comes from a standing order or from a PSR? Like the district court actually has to explain rather than just cut and paste from a standing order or a PSR. And I think the PSR case was Ross.
Your Honor, I don't recall specifically Ross. My apologies on that.
It's all right. I don't, sitting here today, I don't remember it either. I just have this written down.
I know the court does have to provide justification for its sentence, and it can't leave the appellate court guessing as to what the district court's intent was.
Just to be totally candid, let me tell you my concern. Just cards on the table. This looks like a really thoughtful and careful sentencing to me. There's a lot of discussion of the offense conduct, the defendant. I really appreciate all of that. I am left with a slight concern that there was just kind of a massive global cut and paste here, and nobody looked too carefully at whether this defendant matched up with all of these conditions. Some of them, it seems self-evident. I don't need much of an explanation for why this person should not be able to groom youngsters, right? Like, that's fine. But some of them, like the alcohol one, just is not self-evident to me, and I can't find an explanation.
And Your Honor, perhaps if there'd been an objection raised by appellant at the time of sentencing, we could have addressed it more thoroughly on the record for the court, but there was no objection raised to these, to the special condition.
Or maybe the district court would have just said, oh, you don't have an alcohol problem, fine, I'll take it out.
I mean, that's a possibility for sure.
Anything else you want to tell us about today?
I think I've placed all of my arguments on the record for the court. To the extent that I might have missed anything, I'd ask the court to just rely on our arguments that are set forth in the brief. I thank you for the time to discuss the case, and we'd ask the court to affirm the judgment.
All right, thank you, Ms. Crockett. Mr. Compton, you've got some rebuttal time left.
Thank you, Your Honor. Your Honor, I was struck by Judge Harris's statement that this appeared to be a bit of a cut and paste job. And I don't say that, I don't mean to, I agree that it was also a very thoughtful sentencing, and I think this was an egregious case, and I think the court laid that out in its sentencing. But I would refer the court again to a recent case that was again from the Northern District of West Virginia, Judge Groh, we brought here, the Himmelreich case. It's the exact same. The conditions, the explanation for the supervised release. Yes, Your Honor.
I had a question along those lines. We've been talking about a particular condition and whether it fits your client or not. In your brief, did you make any argument that any of the particular conditions are not suited to your client or the crime? My recollection of the brief was that you just said there wasn't sufficient explanation overall. you never drew our attention to any particular condition. Is that correct?
That is correct, Your Honor, and it was a discussion that I had with my colleagues here before we came on this morning, and that goes to, I think, Judge Agee's question before. I think, and this is my fault, that I was just a little bit too generalized and too vague in my argument about the.
Well, I don't at all mean to criticize your briefing. I'm just trying to, sometimes a defendant will say, looking at all the conditions, these two or these three, it's not evident how they relate to my crime, right? Sometimes people will say there's a computer condition and my crime didn't involve computers, so the judge should have explained that, or I objected and the judge should have explained it more. But I was just wanted to clarify that you have not raised any argument about the particular conditions not fitting with your client or the crime, or why perhaps drinking too much might cause someone to reoffend.
That's correct, Your Honor, not specifically, but I agree with Judge Harris that an alcohol condition, for example, does not, imposing that condition does not lend itself for an appellate court to look at this, to believe that the district judge gave an individualized assessment when the defendant has no alcohol issue in his background, and the facts and circumstances of the case do not indicate that alcohol was used to ply the victim or try and lessen her inhibitions.
Do you think that's something district courts could generally consider when it comes to, the justification given was it makes it easier for probation to make sure that they're not going to reoffend? Is that a general truism that if someone's drinking, they might drink too much and not have control of themselves and be persuaded to slide back into their previous lifestyle, or is that too generalized?
I think that is too generalized, Your Honor, and given the requirements of an individualized assessment, if someone doesn't have an alcohol issue, if someone's case does not specifically involve alcohol, then I think that is too generalized to be considered as an individualized assessment. Alcohol is one of them. I know the district court did not have the benefit of the appellate courts, the Fourth Circuit's rulings in Hamilton and Ellis when making, for example, when imposing the employment and the pornography and the internet conditions. And I did not raise those specifically in the brief, so I won't present them here. But those are...
Well, the problem, it seems like to me, in a lot of these recent supervised release cases is that you've had these conditions that have been routinely approved for decades. And now we've had some appellate decisions where the appellate judges come back and pick out on their own conditions that maybe they would have raised had they been counsel in the district court. And I think it's left the district courts in a state of total confusion about how they're supposed to conduct the sentencing hearing without going into a 30 or 40 or 50 page minute explanation for a lot of conditions that seem almost common sense and to which, a defendant has never raised a question. I mean, it just puts the district court in an extremely difficult position where it would seem common sense would say that if it imposes a condition and the defendant doesn't say, I have a problem with this, it doesn't apply in my case, that the district court is still supposed to enter into some sort of extended discussion, item by item, that could go on for hours.
Well, Your Honor, I respectfully disagree. I don't think the court has to go into an hours-long discussion. I agree with, I think what the court was, Your Honor, was saying before about, if yes, you look at the overall, the whole sentence, but that doesn't relieve the district court of making the individualized assessment. And it doesn't mean that the district court has to as we talked about, I think Arbaugh talks about robotically tick through, but it has to be clear to the court. It has to be made. I think what Arbaugh says is that the court has to confidently be able to state that the district court considered certain arguments, and I don't think we have that here when the district judge appears to have not given hardly any consideration, but has in fact done, I think, what Judge Harris was saying, that in certain circumstances, a cut and paste job. I don't know if the court noticed, but I actually made an error in my reply when I cited I'm sorry, my time is up, Your Honor.
No, go ahead. Finish your answer.
I made an error in my reply when I was talking about the language that the court used when imposing the sentence on Mr. Williams. I actually cut and paste because the language is almost identical, and I cut and paste the Himmelwright language by accident because it's almost identical. I didn't notice. And I'm concerned that that's what happened with the district court here, is that it relied just on, this is how we always do it, this is what gets imposed, whether it's specific to Mr. Williams or not.
All right. Thank you, Mr. Compton. We appreciate the arguments from both of you today. As you know from prior experience, we would normally be coming down to shake hands, but we can't do that now. But we hope to be back on track in the fall. So hopefully we'll see you sometime in the next court year in person. So with that, we'll ask the clerk to go ahead and bring in our attorneys for the second case.
Thank you, Your Honor.
Thank you, Your Honor.
Counsel, hear me? All right.
Yes, Your Honor.
Our next case is the U.S. versus Martinez-Mendoza. Ms. Platt, we'll hear from you.
Thank you, Your Honor. Good morning, and may it please the court, Caroline Platt on behalf of Mr. Martinez. The removal order that underlies the criminal conviction in this case is invalid, and this court can rule for Mr. Martinez under either of two theories in the alternative. First, under this court's decision in United States versus El Shami, Mr. Martinez satisfied all three elements of a Section 1326D claim because the government did not show that there was an effective order to show cause and notice of time and place that ever even existed, never mind that was properly served on Mr. Martinez in accordance with Section 1252B, which is the pre-ERIRA immigration statute that applied in this case. The district court held that that was the statute that applied, and that holding was correct. Because there's insufficient proof of the service of the notice of time and place in this case, the in absentia removal order is invalid, and all three requirements of Section 1326D were satisfied, and therefore the motion to dismiss should have been granted by the district court. Actual notice, which in this case we do not think was shown, but even if it had been shown, would not be sufficient under Section 1252B of Title VIII, the 1994 version. Yes,
Counsel,
ma'am.
can I say, because whether or not actual notice would comply with that statute, we're under 1326D. And if there was actual notice, I don't understand why any kind of procedural flaw under the service statute would actually have prevented your client from exhausting his remedies or seeking judicial review. If he had notice, he could have done those things.
You're talking about notice of the time and place of hearing, Judge Harris?
Any kind of notice. I mean, if he has actual notice, if he knows of either, if he knows of the hearing, or really so long as he knows that the order comes down, I don't understand why he can't exhaust his administrative remedies with respect to that order and get judicial review if he actually has notice. And then he can argue in those proceedings, oh, you didn't quite dot all your I's and cross your T's over on the service statute, and then we can deal with it then.
So I would just like to note, Your Honor, in this case, there is no actual notice of the.
Right, I know, but you're making an argument that even
right.
if there were, you would, that is exactly why I asked my question when I did. It was in response to your argument that if there were actual notice, you could still satisfy 1326D, sure. And I don't understand that.
And I don't want to use up all of my time on that because, again, I think the evidence in this case is very clear that there is no actual notice of either the time and place or of the actual.
So if you just want to withdraw the argument, that's fine.
No, that's fine. I don't want to withdraw the argument because I think here's why. I think under matter, because Mr. Martinez has a due process right of service of notice in compliance with 1252B, the 1994 pre-ARERA immigration statute. And that's because under matter of Huete, the remedy for that is non-discretionary. It's not a discretionary immigration relief. It's a non-discretionary termination of the removal proceeding without the entry of an order. And we think there's a due process right to a non-discretionary relief. And it's not cancellation of removal. It's termination of the proceeding without the entry of an order. And
well, Huete dealt with an order of show cause, and I thought it was self-evident that Mr. Martinez got actual service of the order of show cause. He signed it.
Yes, that's correct. So
the question is, what about the notice of hearing? So in the district court, one of the items of evidence that the district court judge relied on was the finding of fact by the immigration judge in 97, I think, that says that Mr. Martinez provided us with his address, and he finds as fact a notice was sent to that address. There's been no return. And the address advisal and the notice will be received as exhibit number 1. Why isn't the district court judge entitled to rely on that?
So, Your Honor, this is, I'd love to pivot to that, Your Honor. If you look at page 116 of the joint appendix, that's the immigration court's checkbox, which says exactly what you just said. And if you look at pages 436 and 437 of the joint appendix, that's the actual transcript of the immigration judge's in absentia proceeding. And I think because the order to show cause, which was served on Mr. Martinez, I'd like to note, if I may, that does not distinguish this case from El Shami. In El Shami, the order to show cause was also served on Mr. El Shami.
Right. What I want you to do is tell me why the district court can't rely on that as a finding of fact in this case.
That is what the record says, Your Honor, but that is not sufficient notice of a certified mailing of the notice of time and place. And here is why. Every single pre-ARERA immigration case that the government has cited at any point in this proceeding, none of them have had a lack of actual proof of certified mail, as in from the U.S. Postal Service. The A file in this case does not contain a notice of time and place of hearing. There's no proof that that document ever existed.
Yeah,
and there's
that may not, right, I understand that, but that's not what the immigration judge found.
Well, but the immigration judge, I would also like to note, Your Honor, in exactly what you're just referring to, if you look at page 436 of the joint appendix, which is the actual transcript, it refers to one exhibit as being 2 pieces of paper, which again, to me, is not clear, unequivocal, and convincing proof that the notice of time and place of hearing that actually was the corrected notice of time and place of hearing ever existed.
If we were back in 1997 and you were objecting in the first instance, that might be a different case, but we're not. We're 24 years later. So we have a finding of fact by the immigration judge, and I'm not understanding why the district court can't rely on that.
But Your Honor, without Mr. Martinez having been there was no one there to object on his behalf because it was an in absentia proceeding. That's exactly why El Shami holds what it holds. Without proper proof,
right? But in
El
Shami, wait a minute, counsel. In El Shami, the reason that the court got where it did was because the government stipulated there was no evidence, and you don't have that here. Fourth Circuit said it's uncontroverted evidence. Well, here you've got evidence that's in conflict.
But Your Honor, okay, so if I may bring up a clear error case, and again, so it's the government's burden on the immigration law to show clear, unequivocal and convincing evidence. And I think it's a question of law what makes that standard.
Counsel, but again, I think that would have been true in 1997. But now that you're under 1326D, I thought the burden was on the petitioner, your client, to show that he didn't get right. He has to prove the burden's shifted now, hasn't it?
Yes, and based on the A file that we have, which came from the government, we're working with the documents we have, Your Honor, to meet that burden. But the legal standard of who has to prove the mailing is still on the government, which is where I think we get into the legal question of what is clear, unequivocal, and convincing evidence of the mailing. And every single case the government has cited, there is actual U.S. Postal Service proof of the certified mail. Whether it's that it couldn't be delivered, whether it's there's a return or a change of address, there's always some piece of paper from the U.S. Postal Service that proves that certified mail was at least attempted, which is exactly what's lacking in this case. What
about the matter of Grivaldi, which has been adopted by several circuit courts, that ends up saying that proof of the actual service or receipt of the notice by the respondent is not required?
So Grijalva, I don't know how to pronounce that, Your Honor. I don't speak Spanish, but that is we noted in our reply brief. That case is distinguishable because there the lack of return comes because there's proof of the attempted mailing of the certified mail, as in the U.S. Postal Service piece of paper that at least they tried to send it, which is what is lacking in the A file in this case. So that again is proof of the attempt to mail the thing. And here again, I'm very concerned by the discrepancy in the immigration record about what is Exhibit 1, the order to show cause, or this corrected notice of time and place, which again is not in the A file. There's no proof that this document with the actual time and place of hearing exists.
Putting aside the immigration court's finding, you also have the testimony from Agent Lamb, who's asked, is it your belief that the defendant told you he had an immigration hearing pending? The answer is yes. There's an objection. The objection is overruled. There's no assignment. Just hang on, counsel. I haven't finished my question. So there's no assignment of error to that as an evidentiary error in this case. So why isn't that also an additional factual evidence the district court could rely on for either actual or de facto notice of the hearing?
That is not what Agent Lamb's testimony was, Your Honor. As we lay out in our reply brief, Agent Lamb testified clearly that he had no memory of what happened on that date. And he also said that he was certain that he had gotten the evidence. I just read you, counsel, I just read you what he testified to. And there could be different ways to take that testimony, but the district court was entitled to analyze it along with the other evidence. Agent Lamb testified that he was certain he got the notice, the information about the hearing from a records check, and that it was possible that Martinez had told him that, but he thought it was more likely that he had gotten it from a records check. In addition, the outcome, if we want to get to the voluntary return issue, the outcome of that. Oh no,
I'm sorry. Just before we move off notice, I did tell me I'm having trouble with 1326D. I understand your notice argument. I don't understand your 1326D argument. If I assume hypothetically, it's 100% obvious there was never any notice of this hearing, and that would make the hearing itself I'll assume also the hearing itself, which he didn't have notice of and couldn't attend, that was a violation of due process. But to excuse the first two prongs of 1326D, you have to show that due process flaw, because he didn't have notice of the hearing, that's what caused him not to challenge the deportation order administratively or judicially. It precluded judicial review. And I'm not understanding that. If he got notice of the order, forget the hearing, but he got the order, and he had been told in the notice to show cause, if there's an order and there's a problem with it, you can administratively exhaust and you can appeal it, then how would any due process violation relating to the hearing have prevented exhaustion or judicial review? Do you see what I'm saying?
I do see what you're saying, Your Honor. And I have two answers to that question. And I'm not sure either of them will satisfy you, but they're the legal answer. And the first one is that does not distinguish this case from El Shami.
Well, I understand your point that he got the notice, but the court actually says in El Shami that not because he didn't attend the hearing, he was deprived of his notice of the right to challenge or appeal the order. That's not true here.
But Al-Shami as well was served with the actual order
Well,
to show
I know,
cause,
and I can't really explain that, but I don't know how I could say because he didn't know about the hearing, he also was deprived of his chance to exhaust or appeal the order.
Well, so my answer to that, which is separate, is that this is related to the voluntary return issue, is that there are rules about when you can file a motion to reopen that are not time bars, there's also something called a departure bar. I think it's 8. I don't want to get too far into civil immigration law because that's, I think you all know, not my area of expertise as an assistant federal public defender, but there's something 8 CFR 8.1, which is the pre-ARERA law. I'm not promising you that's the current law. That was a departure bar as well, that you could only file motions to reopen in certain.
So this is sort of where I was. This is where I left off on your argument. So your notice argument maybe isn't an independent argument. Maybe you need the voluntary return to get you through 1326D.
If you want to depart from the four corners of Al-Shami. And the other part, Your Honor, is that under Huete, this is related to my due process answer from before. Under Huete, he has a due process interest in the termination of the proceeding just based on the notice because it's a non-discretionary remedy that Huete grants.
They could reopen the hearing, right? They would have to terminate this one. That doesn't mean he can. He's good forever.
I want to say this carefully. My understanding of Huete is that termination is a termination. They couldn't reopen it. They could file a different proceeding, but this proceeding would terminate.
Okay.
And
but
then
he could still be removed.
But
right.
if you look
at
the
still
language,
be removed.
But that's a different proceeding, Your Honor. And if you look at the language, this gets me back to the statutory language of 1326D. It talks about this order. And so if we're challenging the fundamental fairness of this deportation order, whatever other proceedings or whatever other thing might happen to him with INS or now ICE in the future, we're challenging this removal order. And so I don't have to prove that he could never be deported by ICE under any circumstances.
No, but you have to show prejudice under, you'd have to show prejudice under 1326D, which usually entails some sort of a showing that but for these procedural errors, he could not actually be removed.
And that's why the termination holding of Huete is so important, again, under pre-ARERA immigration law, because termination of the proceeding is different than just saying like a discretionary cancellation or something. It's an actual termination of these charging documents.
If you want to talk about voluntary return, you probably ought to move on to it.
I really do, Your Honor, because clear error findings of fact, I understand that they're rare. I'd really like to draw the court's attention to a clear error case called United States versus Span, which is 789 Fed 3rd 320, which I see that my opening time has expired.
Yeah, go ahead and quickly finish your answer.
Thank you. So there's a case called United States versus Span that has to do with clear error findings of fact, where the underlying documents are unclear, where they've been edited and there are crossed out handwritten notes. It's an ACCA case about prior judgments, but it's really remarkably on point. And I can probably get into this in rebuttal as well if the court will indulge me in having a rebuttal about something we haven't yet gotten to. But 789 Fed 3rd 320, this court found a clear error finding of fact in a case with underlying documents that are so unclear that the clear weight of the evidence considered as a whole did not allow the district court to find the fact that it found in that case, which I think is incredibly on point with regard to the district court's finding of fact in this case, that the disposition on the I-213, where it said that Mr. Martinez was voluntarily returned to Mexico in INS custody, didn't happen. I think it's very clear in this case that did happen, and I'm happy to get into that more in rebuttal. But here, that is a clear error finding of fact that I think this court should reverse, and that would be again, both if the court wants to tie it into the first due process argument, but also as its own separate due process violation that would entitle Mr. Martinez to reversal. Excuse me.
All right, you've got some time on rebuttal, Mr. Young.
Thank you, Your Honors.
Good morning, Your Honors. May it please the court. There are two straightforward ways to resolve this case. First, the government agrees the defendant has a clear statutory right to move to reopen his immigration proceedings at any time for lack of notice. But he was informed of that right when it was read aloud to him in Spanish when he was personally served with the order to show cause in this case. And he's never exercised that right. And for that reason, he hasn't exhausted his administrative remedies under 1326 D1. Second, the defendant's fundamental unfairness claim, as I understand it, is that the lack of a returned receipt in the file would result in automatic termination of the removal proceedings. And that assertion is wrong. And it's wrong for several reasons. First, the applicable due process right is a right not to be removed in absentia without notice. It's not a right to enforce certified mailing rules. And here, unlike in Al-Shami, the defendant has not offered any affirmative evidence at all that he actually lacked notice, which is another reason to affirm. Let me start with the government's lead argument here, which is failure to exhaust administrative remedies. At least 2 circuit courts have reasoned in exactly the way that the government is asking the court to reason with respect to the order to show cause. There's a case called Orita Campos from the 7th Circuit, which is cited on our brief at pages 26 and 30, which reasons in exactly this way. And the 9th Circuit in a case called Hinojosa Perez, which is cited in our Rule 28J response, reasoned in exactly this way. In a lack of notice case, where the defendant is personally served with an order to show cause that advises him of his right to reopen at any time, the expectation is that he has to exhaust that remedy. And importantly, and this is another point we make in our 28J response, because there's no time bar, my understanding is that it is not unusual for immigrants who were removed in proceedings that started before IRERA took effect to much later, a decade later, 15 years later, file a motion to reopen. The statutory provision is 1252 lowercase b C3b. And we cite Ramos Portillo in our Rule 28J response, which is a 5th Circuit case from 2011. We also cite a case called Sanchez from the 6th Circuit in 2010 on our brief at pages 26 and 30. And those are cases where the immigrant comes forward years after his pre-IRERA proceedings have closed, and he files one of these motions, and he says, I never got notice. And then that's adjudicated by the immigration judge and the BIA, and if the defendant feels there's an error, and there's a denial of a motion to reopen, he can take an affirmative appeal to a court of appeals, which is exactly what this defendant could have done. This, I think, is a helpful segue to my friend's points about Al-Shami, because I had the exact same question. Al-Shami is a pre-IRERA case, and I could not figure out why Al-Shami does not quote the order to show cause at all. The government's brief in that case is not available on PACER, but it is available on Westlaw. And I think the answer is that the government did not squarely present the argument. There's one substantive paragraph in the Al-Shami brief at pages 15 through 16 that mentions the order to show cause in passing. It doesn't quote it at all. And the government's lead argument in that case, as I understand it, was that the defendant could have taken an appeal, which I think gets the sequencing wrong. In a lack of notice case, the sequence is you file a motion to reopen with the immigration court. If that's denied, you then take an appeal from the denial of that motion, which is why this defendant also can't satisfy 1326 D2. All of this was available to him, and he never did it, despite the fact that he was removed both in 2005 and in 2010 before this 1326 prosecution was initiated. Let's talk a little bit about fundamental unfairness, because I think a couple of different things are being conflated. One of the things that seems clear to me as I was preparing the case is that there are 2 distinct due process rights that I think it's helpful to separate. There are cases where an immigrant comes forward in a direct appeal from a removal order, and he lodges a due process challenge to the manner of notice. And we cite 2 of those cases in our Rule 28J response, Papa from the 9th Circuit and Aneen from the 11th Circuit. And in those kinds of cases, what the courts of appeals have said is, you don't have a due process right to any particular form of notice. You have a due process right to notice reasonably calculated to reach you. And I haven't seen a single case from a court of appeals or the BIA that says any kind of mail, whether regular mail or certified mail, isn't intended to reach the person with some degree of reasonableness. There's a separate due process right not to be removed in absentia without actual notice. That's what Al-Shami talks about. We agree completely. The defendant absolutely has a due process right not to be removed without actual notice. But the problem in this case is the defendant has never made any affirmative showing on that score at all. And on this point, 3 things are working in tandem with each other. And I think it's helpful to separate them out. So first, I respectfully disagree with my colleague, Ms. Platt, about fact findings. In the district court's opinion at JA 190, he says that the defendant here told immigration officials during his encounter with them in Galveston that he had an upcoming hearing date. So that's a fact finding. There's then a second hearing, and at the very end of that hearing, he says, nothing I have heard today, this is Judge Hudson, causes me to question the legal or factual conclusions I previously made. So even after hearing from former INS agent Ray Lamb, the district court judge adhered to his fact finding that the defendant must have had actual notice because he's the one who told immigration officials that he had an upcoming hearing during the Galveston encounter. That's the first thing about notice. The second thing is set that aside. Just assume for the sake of argument that the court felt that that was clear error, which I don't concede that it is, but let's assume that. When there's a certified mailing, but there's a failure to obtain a return receipt, the certified mailing just becomes a regular mailing. And under this court's 2006 decision in Nabagwire, there is a presumption of receipt that attaches to regular mail. Now, the difference is, under the BIA's decision in Grijalva, if it's certified mail with a return receipt, there's a really strong presumption. And the BIA has said the defendant cannot rebut that presumption on his say-so. The defendant can't file an affidavit that says, I never got notice, and reopen his hearings. But what this court said in Nabagwire is the presumption of receipt from regular mail is actually pretty easy to overcome. You say that you didn't get notice, and then you point to whatever other kinds of circumstantial evidence you can. But the point is that presumption ought to apply here, and it's never been rebutted. The defendant has never come forward in any way, shape, or form and said, I didn't have notice. And that leads to my third point, which is kind of like a practical point about what would happen in reality. Imagine this defendant were to file a motion to reopen his immigration proceedings, and he were to say, under the provision that says he can move to reopen at any time for lack of actual notice. He would say, there's no certified receipt in my file. And the immigration judge, I think, would say, okay, did you get notice? And if he said, I declined to answer, there's no way those proceedings would be reopened. That's why this case is totally different from El Shami. I mean, El Shami, Judge Agee was exactly right about this. It says expressly at page 663 that the court finds that El Shami did not have notice. And the reason it finds that is because El Shami and his wife both testified in the 1326D proceedings. This defendant didn't. So even setting aside the district court's factual finding at JA 190, you're under the Nabagwire presumption, and there's nothing to rebut it at all. There's a total absence of evidence. So in those circumstances, I agree, Judge Agee, with your point. The immigration judge here made a finding in his removal decision at JA 116 that a certified mailing had gone out into the mail. It's just that there was no return receipt. And there's no independent right to quash immigration proceedings for lack of a return receipt, which leads to Huete. And I'm happy to address that, but Judge Harris, I think you may have a question.
I do. I guess I wanted to ask you to put to what I totally understand your argument about notice of the hearing. But if he didn't get notice of the deportation order itself, right? If he didn't get notice of the order because he had been voluntarily returned to Mexico, and that was fundamentally unfair, then that would excuse the failure to exhaust and to seek judicial review, right? Because he didn't know there was an order.
I think it might, and let me explain the doctrinal framework, because it's a very weird factual scenario. And then I want to talk about clear error. If the defendant was voluntarily returned, it was done illegally. Both of the immigration officials testified to that, and they're exactly right about the relevant regulations. I can provide them if it would be helpful. You can't allow someone to voluntarily return after immigration proceedings have started in immigration court. So then the question becomes, and then apparently the immigration judge would have entered a removal order, either having been told that and not caring or not knowing that. And so the question
let's assume not knowing, nobody told him.
So the question is, what do you do with that? And I think, so there's a case that was argued at the Supreme Court like 2 weeks ago called Palomar Santiago, which is going to be the first criminal 1326 case to come down since Mendoza-Lopez. The Solicitor General in their brief takes a pretty aggressive stance that it's very rare to be able to excuse D1 and D2. But they say you might import some of the exhaustion doctrine that exists, for example, around the PLRA and like in Blake. And one of the examples that the Supreme Court has given for why you might excuse failure to exhaust is if the government has affirmatively misled you. And assuming everything you said, Judge Harris, you might apply that here, because I think what would have happened is this man would have been put on a bus, driven 7 hours from Houston to the border and told, you're good to go. Right. And he would have reasonably
right, because he said, right, because the form said he waived hearing, right? So he doesn't think there's going to be a hearing. He's good to go. Right.
Now, let me add one curly Q, and then let me talk about clear error. The curly Q is, I think you might do that if this 1326 prosecution were like his first interaction with the immigration system since his voluntary return. But he was removed again in 2005 and again in 2010. And in 2009, he checked another form that said he did not want to contest removability. So I'm not actually even sure you'd excuse D1 and D2, even in the really weird voluntary return scenario in this case, because what would have happened? In 2005, he would have been told, there's a pending order of removal. We have to take you back to Mexico. And he would have said, no, that was all cleared up.
Yeah, I get that as a matter of common sense. I totally do. Like now, the failure to exhaust is not caused by what happened back in 1997. It's caused by his voluntary decision to give it up. But I couldn't find any cases saying that. Can you?
No, I haven't. And I think part of the reason, it gets into this really weird distinction between a defendant's burden under 1326D and collateral estoppel. What sometimes happens is people start going, but there's no collateral estoppel in criminal proceedings. And that's, of course, totally right. And the Assistant Federal Public Defender said that below here. But I don't really think it's a collateral estoppel issue. I think there's an intervening cause, which is in 2005, you were told again that there was a removal order and you ought to have acted then. Let me talk about clear error, Judge Harris, as I said I would. Under Bessemer City, clear error exists if the court is left with a firm conviction that a mistake has been made. And if a district court judge...
Are you moving to, even though opposing counsel only got to touch on voluntary removal, I assume she's going to want to discuss that in rebuttal. So you're going to talk about that as part of this discussion? Okay.
Yes, Your Honor. I want to talk about voluntary removal and Huete before I sit down. So let's do voluntary removal. Under Bessemer City, if the district court judge adjudicates between two plausible explanations, that's not clear error. There are at least 3 independent reasons why Judge Hudson concluded that this individual was not voluntarily removed. 1, both the immigration officers testified that it would be flatly illegal and contrary to regulations, which is right. 2, they both testified that there would be at least 3 documents in the immigration file attesting to the fact of voluntary removal, the change in bond status, and the transportation 7 hours away from Houston, and none of them appear in the file.
Okay, counsel, can I stop you on that one? Because I did think the district court relied on that heavily. And I have to say, and I do not mean this in an even remotely snide or judgmental way, but like we're starting from the premise in this case, right, that the paperwork is not in order. Like one way or another, the paperwork didn't get done right because either some documents are missing or somebody put VR on the form by mistake. So how... Do you hear what I'm saying? How much can we rely? Like we can't, under no scenario is the paperwork proper in this case. So how much weight can we put on which way it's improper?
I have 2 answers, Judge Harris. The first is, I totally take your point, truly. But it's one thing to like have a confusing form about the Galveston interaction in the file. And it's another thing for 3 separate documents to be missing. If it were just 1, I think the case might be much harder for me, but here it's 3. And so I think that matters. And then the last thing, I said there were 3 points. Former INS agent Lamb testified that there was a local policy in Houston that they never VR'd somebody with a criminal history. And this defendant had a criminal history, had been convicted of forgery and given a 120-day sentence. So that's 3 independent reasons. Let me say this, Judge Harris.
So what about Agent Lamb's testimony that putting VR on the form was just a mistake I made?
Yes.
I would have thought that would have been pretty powerful testimony on behalf of the government.
Absolutely. I should have added that as a 4th reason, Judge Agee. You're exactly right. When he was put to the question, he said, it seems clear to me in retrospect that this was a mistake. Let me offer, sort of step outside the transcript of the hearings. The federal public defender did a very good job below of pointing out that the Galveston form seems to have been written around 4:30. And then there's a separate waiver form at 5 o'clock where he says, put me on a bus, I want to waive my hearing. I think one interpretation of what happened is that for at least half an hour on that day, they thought they were going to VR him. And then somebody realized exactly what Agent Lamb and Officer Chin testified to, which is, wait, we can't VR him. And he wasn't. That seems to me to be the most plausible reading of this record. Before I sit down, I really want to address Huete, because another distinction between this case and El Shami is the prejudice argument in El Shami was, if I had been advised of my right to seek discretionary cancellation, I would have done it. There's no claim like that here. The only prejudice claim is what Ms. Platt has said, which is under Huete, a service defect terminates the proceedings. That is wrong. And it's clear when you read Huete, it's wrong. Huete relates only to orders to show cause. And the reason Huete comes out the way it does is because there are two regulations that relate only to orders to show cause. The first regulation says you can accomplish service of an order to show cause by regular service or personal service. But if it's the defendant doesn't show up for his hearing, it has to be personal service. And then there's a separate regulation that says personal service includes all of the following, and the last one is certified mail return receipt. And what the BIA says is, it doesn't make any sense to say that certified mail return receipt is a species of personal service unless the receipt says that it was put in the hand of the immigrant or in the hand of a responsible person at the household. All of that is only about orders to show cause, all of it. And we cite cases in our brief like Delicia Pena Paulino and even Grijalva, which just say flatly, the Huete right does not apply to notices of hearing, full stop. So I think back where I was at the beginning, which is what would happen is this defendant would file a motion to reopen. The immigration judge would say, okay, return receipt. Did you have notice? And then the defendant would have to say something in a way that he didn't in the district court. And because there's no evidence on the other side showing that he didn't get actual notice, these proceedings were not fundamentally unfair, which is a reason to affirm apart and in addition to the failure to exhaust administrative remedies. If the court has no further questions, the government will rest on its feet.
All right, thank you, Mr. Young. Ms. Platt, you've got some rebuttal time.
Thank you, Your Honors. I don't want to. I would like to spend my time talking about voluntary return, but with regard to Huete, I would just like to note that we've distinguished Grijalva in our reply brief, and the statutory requirements for the notice of corrected time and place pre-ARERA are not different than the order to show cause. The statute is exactly the same, 1252B. With regard to voluntary return, as I said, the standard for clear error from this court has been met. If I could note, my friend on the other side has said that Agent Lamb clearly testified that it was actually illegal pre-ARERA to voluntarily return someone who had a prior conviction. That is not what Agent Lamb testified. If you look at page 294 and 295 of the transcript, what he says is, quote, at the very least, it was the local policy. I don't know if it went higher than that or not. I don't know. That's the testimony in the record. His second argument, my friend on the other side, had to do with the documents in the record and how they were inconsistent with a voluntary return. The actual documents in the record are an I-213 form, the disposition of which said voluntary returns to Mexico. Agent Lamb testified that the other documents he would expect to see in the file include an I-826 form, which is the notice of rights, which is in fact in the record at JA 326. The Officer Chin said he would expect to see the bus manifest with the list of passengers, but Officer Chin also clearly testified that was not required to be in every person's A file. So that document is not in fact missing from the A file, even to take into account what Judge Harris said about the fact that this file is apparently sort of a mess either way, and was also disclosed to defense counsel in pieces. There are other documents, if I may say, there's other evidence that supports the VR having happened in this case. The form was distributed to DD&P in Agent Lamb's handwriting. He wrote in that it should go to them, which is the people who are actually tasked with sending people to Mexico on a bus. In addition, Mr. Martinez tried to enter the United States in August of 1997 and was turned back at the border. That's a document in his A file. We also have, and this goes, I think, Judge Harris, also to your question about whether he got the notice of the actual in absentia order. Judge Hudson found, as a matter of fact, that my client was in Mexico in late April through May and June of 1997 because of his wife's testimony. That is a finding of fact at JA 322 and 23 that it was made and shows that Mr. Martinez was in Mexico. That also means he did not receive mail in Houston in May. He never received the in absentia removal order.
Well, so it may mean, I know that's a conclusion that you reach, but it's not necessarily the only conclusion. He could have very well received mail at the address he gave to the immigration agency, and he could have been in Mexico. And I mean, you can watch television any night and see thousands of people coming back and forth all the time. But your argument strikes me as one that's a very good one at the district court level. But here you've got other evidence in the record. For instance, you have Agent Lamb's testimony when he's asked, with regard to the VR line, would you have normally scratched that out? Answer, yes, sir. You just didn't do it in that case. Correct. Is that line disposition VR'd to Mexico indicative that he was in fact voluntarily removed? No, sir. So wasn't the district court allowed, when it considers all of this evidence, to determine from all the evidence which it thinks is dispositive?
In this case, Your Honor, I submit that the finding that Mr. Martinez was not voluntarily returned was clear error under this court's standard.
Well,
for example, United States versus Span.
It seems like you can only reach that if you ignore the other evidence in the record.
The weight of the evidence in this case is clear that Mr. Martinez was voluntarily returned to Mexico. The only evidence that it didn't happen was because the government doesn't want it to have happened, because it helps him in this case. And again, Agent Lamb was clear that he does not remember what happened on that day. There was no.
I just read you his testimony.
He was speculating, Your Honor, and any evidence that Mr. Martinez was voluntarily, or traveling back and forth multiple times in April, May, and June,
I know
is also
that's your
speculative.
take on the evidence, but that's not what the questions say. It says you just didn't do that in this case. Correct.
Agent Lamb said he had no memory of that date. So any speculation that he made about what he did or did not do on that date was also speculative. And so again, we would submit that the great weight of the evidence in this case is that Mr. Martinez was voluntarily returned, and that makes the in absentia hearing and entry of the order also fundamentally unfair for the reasons that we've laid out in our brief. This is the rare, clearly erroneous finding of fact by a district court. And again, we'd ask the court to look at the United States versus Span and see that it's very, very similar. I know that my time has expired. I would just also like to note that, in fact, collateral estoppel does not operate against a criminal defendant. So the fact that Mr. Martinez's prior counsel has not raised this objection to the previously reinstated. There's only one removal order that's ever applied to Mr. Martinez. It's been reinstated. Collateral estoppel does not operate against a criminal defendant. And so for all of the reasons that we've argued in our briefs, Mr. Martinez would like the court to reverse the district court's denial of the motion to dismiss on de novo review.
All right, Judge Harris, Judge Rushing, either you have any further questions? Hearing none, thank you, counsel. As you know, our normal practice would be to come down and say hello. We can't do that now, but we hope to be back to normal in the fall and hope you'll return then, and we'll be able to do that in person. Until then, stay safe, have a good summer, and I'll now ask the clerk to adjourn court.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Judges, I will move you into the robing room.